discussion of the sort of procedural context, the differences in class actions and settlements thereof. And now we're going to talk about other implications of Morrison in terms of other United States laws and whether they'll apply overseas. And for moderating that panel, I'm going to turn to my distinguished colleague, Brian Landsberg, who's actually himself dealt with this area in one of the Global Issues books that he did, dealing with employment discrimination, because Morrison is picking up from a case called Aramco, in which there was an allegation of employment discrimination. What do you expect out of Aramco? And the question was whether U.S. anti-employment law would apply to this discrimination, some of which is manifested in Saudi Arabia, as I understand, right?
It was a strange case, yes. Okay. So a guy was hired to fly helicopters, and then he found out that in order to fly helicopters to Mecca, you have to be Muslim because, and if you're not, that you face having your head chopped off. That's according to the facts of the case anyway. So he then sued for religious discrimination because he didn't really want to do that. So. Okay.
So the Supreme Court said U.S. employment law doesn't apply, which Congress then legislatively overturned. But nevertheless, good precedent that then sets up Morrison, which says that our anti-fraud doesn't apply overseas, depending on what the transaction is. And now we're going to talk about other implications. So I tried to set a sort of precedent, and everybody's aboard. Brian, please take it away.
Fine, thanks. Actually, this case, we'll be talking a little bit about the Kiobel case, which finds its roots in the Filartiga case, where when I was with the Department of Justice, I worked on the brief that we filed there. So in any event, we have a wonderful panel who's going to speak, and I'm going to just sit down and enjoy them and keep time, I guess, and then try to help with questions afterwards. And I think we'll have plenty of time for questions. The first speaker is Vivian Curran, distinguished faculty scholar at the University of Pittsburgh School of Law, who's going to talk about extraterritoriality and universal jurisdiction. You have her bio in the materials. I'm very impressed that the Republic of Austria gave her the Grosse Goldene Ehrenzeichen. I don't know if I know anybody else who's got that. And she also worked on a brief in the Kiobel case. And William Dodge from UC Hastings is going to be talking about, his title is Understanding the Presumption Against Extraterritoriality After Morrison v. National Australia Bank. And among his many accomplishments, such as clerking for Justice Blackmun, he also is the co-reporter for the ALI restatement of foreign relations law on the subject of jurisdiction. And he's served with the legal advisor's office in the State Department just last year, I guess. And finally, Professor Kenneth S. Gallant. Gallant. Well, I think Gallant sounds really good. So,
fine with me.
From the University of Arkansas at Little Rock, is going to be talking about whose law must we obey? Very interesting question, and he's writing a book that's currently titled "Whose Law Must We Obey? Criminal Jurisdiction in Transnational and International Law," and he's previously written about the principle of legality in international and comparative criminal law, which was published by the Cambridge University Press. So it's a great panel, and we look forward to hearing your wisdom. And so let me turn it over to Professor Curran.
So I want to thank the organizers, Gevurtz in particular, for inviting me here. It's really always a pleasure to be at this law school, which does such great things in global law and transnational law. So for those of you who were here for the morning session, we fit into that slide that Professor Gevurtz had up that said Panel 2, Other U.S. Statutes 2. My talk will be about in the Other U.S. Statutes rubric. So a couple of years have passed now since the Morrison decision was decided, and some interesting things have been happening from the perspective of extraterritoriality. And the first thing I want to mention is the court saying in the Morrison decision that the presumption of extraterritoriality does not depend on a finding that there is a risk of U.S. law conflicting with the law of other countries. In this respect, our colleague Bill Dodge has pointed out that this is in keeping with a general trend of the U.S. court away from the Charming Betsy canon. But in any case, that's the first point I want to make. And then we have the Nicastro case, in which the court tells us that creating an independent distributor can insulate a foreign manufacturer from jurisdiction in the United States, from liability in the United States, where the foreign manufacturer does not target sales in a particular state, although the foreign manufacturer did target sales in the United States in general, knowing that the product could end up in any state in the United States. So a plaintiff who was then injured by the product in a particular state in the United States was not able to sue. So in 2010, which was the year that the Supreme Court decided the Morrison case, and as you may remember, it was the year that the Supreme Court also decided Citizens United, the Second Circuit decided the case of Kiobel, which was Kiobel versus Royal Dutch Petroleum, which was an alien tort statute case. And the Second Circuit decided in that case that corporations are immune from tort liability under the alien tort statute, under the ATS, that only natural persons can be liable. So some have posited that there has been an increasing hostility towards extraterritoriality in general in the United States, and that this has culminated in the Second Circuit's opinion in 2010 in Kiobel. Now, Morrison dealt with manipulative and deceptive contrivance, that's the language of the statute, under the Securities and Exchange Act. Nicastro, as we just mentioned, was a products liability case. So, unlike Kiobel, neither Morrison nor Nicastro dealt with universal jurisdiction. In other words, neither of those cases dealt with the gravest violations of human rights, which universal jurisdiction occupies itself with. Universal jurisdiction, in theory, by definition, is always going to be extraterritorial in effect, right? It implies that by definition. However, it applies only to a narrow scope of cases, a narrow category of cases. The ATS statute itself defines those cases as being those which are in violation of the law of nations. And so it's this factor which would set ATS cases apart from Morrison and Nicastro, except for one thing. And that one thing is that the modern generation of ATS cases also deals with multinational corporations. Multinational corporations have, in the last generation of ATS cases, become the targeted defendants. So Kiobel, in effect, is situated at a juncture of two lines of cases. The first line is the Philartica line, which Professor Landsberg mentioned a few moments ago, and that was the ultimate, as we post-Morrisonians would call it, foreign cubed case. Philartica gave a new start to the Alien Tort Statute, which had been enacted in 1789, and I think had been, in fact, applied maybe 2 times between 1789 and 1980, when Filartiga was decided by the Second Circuit. And that was a case which involved foreign plaintiffs, a foreign defendant, and acts which occurred in a foreign country. So in that sense, completely foreign cubed. Now, Kiobel then is appealed to the United States Supreme Court on the issue of whether corporations can be held liable under the Alien Tort Statute. It turns into an extraterritoriality case essentially at the first oral argument already. The court seemed much less interested in the question that had been appealed than in the question of extraterritoriality, and neither party got to say a whole lot about corporate liability, although that's what both parties were primed to talk about. So Frank Gevurtz told me about this conference sometime last fall. I was sure that by now this case would have been decided, so this was supposed to be a completely different talk to you, but here's what we do know. We know that, unlike in Morrison, where the court said that the presumption of extraterritoriality is not a question of whether our law would risk a conflict between our statute and the laws of other countries, what the justices focused on in both oral arguments, and there were 2 different oral arguments in this case in the Supreme Court, their focus was directly on the practice of other countries. So it was on foreign law, which in my view is so important. And it's worth emphasizing that this focus did not arise from the issue of what the law of nations was. So it's clear that substantively all of the relevant nations condemn the crimes against humanities that were alleged to have occurred in Kiobel. The issue asked about repeatedly is this: is the United States alone in allowing civil as opposed to criminal jurisdiction extraterritorially in universal jurisdiction cases? Now, the alone standard is also not derived from the statute's terms or its application. So nothing in the statute says that. And then in terms of the application, what the Sosa Court, now the Supreme Court in 2004 heard one Alien Tort Statute case, that's the Sosa case, and we know from that case that being alone has nothing to do with the standard. Rather, what this court tells us is that in order to qualify as an ATS act, an act has to be a crime universally acknowledged to be such in the view of civilized nations, one of those terms that makes one cringe and isn't the sort of terminology that best endears us to other countries, but we are stuck with that terminology. But that's what the Supreme Court tells us. So in recent years, let me just switch gears a tiny bit. As you may have suspected from what we heard this morning, other countries and the European Union have begun to look with a lot of interest in the U.S. model of class action cases in tort law and the ATS as well. Of course, this is especially the case as the catastrophes that have been going on in our time have become greater because of newer technologies, and they have become transborder. Now, the U.S. system of class actions became quite familiar to many lawyers and many legal scholars in the European Union member states with Holocaust-related compensation class actions which involved their countries or which involved neighboring countries and which were matters of huge discussion when they were going on. In France in 2006, a case that also involved a Holocaust-related issue was brought against the French government and railroad, the SNCF, in tort law, and it was modeled on the U.S.-style tort action. It wasn't a class action because class actions can't be brought there. The plaintiff had become thoroughly familiar with the U.S. tort-style case, and the lawyer couldn't, for technical reasons, sue in criminal court. So what was a big surprise is that the lower court ruled in favor of the plaintiffs, although he was reversed on appeal. Now, it was still a landmark case because the French state did not appeal, so that judgment still holds. In recent years, both Italy and Greece have allowed civil proceedings and damages to be awarded against Germany for Jus Cogens crimes, violations rather. Now, those judgments, however, were unenforceable in Germany, and then they went up to the European Court of Justice on that issue of enforceability. Under Brussels I, on one level, such judgments would be entitled to automatic enforcement. However, what the ECJ said was that Germany was right because although they were brought in tort law, they in fact involved criminal actions. They were universal jurisdiction crimes maybe, but they were on their face tort actions, but underlying this they were criminal violations, and therefore they were not entitled to Brussels I recognition. So in March of last year, so this is days after the first Kiobel Supreme Court hearing, a Dutch court granted civil damages to a Palestinian doctor for torture and imprisonment endured in Libya under the Gaddafi regime. I don't know if some of you may remember this case. This was the case of the Bulgarian nurses and the Palestinian doctor who had been accused of spreading HIV in Libya. So he found refuge in Holland, and so this was the lower court. And then October 11th, another Dutch court, this is my Shell case, not the Shell case that you were mentioning, and that's why I was so interested. I left it in 2010, October of 2012. Another Dutch court said it had jurisdiction in a civil suit brought by Nigerians against Shell for polluting the Niger Delta. So all plaintiffs were non-national, all acts concerned another continent. So this would be the first of its kind, and we are waiting to see what will happen. Of course, when this was mentioned, these kinds of cases are mentioned to the Supreme Court. Justice Scalia, for those of you who may have read the transcript, said, well, these could have been wrongly decided under Dutch law. But we will see. So by and large, however, my point is really that it is a considerable problem for civilian states to accept the idea of universal jurisdiction for civil cases of Jus Cogens crimes where there has been no criminal trial at all, where no criminal trial has occurred, where no criminal trial is in sight. Now, from the point of view purely of international law, it should not necessarily be a problem. The International Court of Justice told us in the Lotus case that each state can choose to apply universal jurisdiction civilly. Now, the Lotus case is a big controversy, hotly debated. I don't depend on the Lotus case for my point, although it has really never been repudiated by the ICJ. Barcelona Traction explains it, qualifies it a bit. But let me just say, you have Ian Brownlee in the Principles of International Law saying the same thing. But of course, we know that universal jurisdiction by definition concerns states that are other than the forum state. So the problem is you will have acts and parties whose nexus with the forum state is going to be of lesser consequence than with non-forum states. And so there is a problem with the idea of extraterritoriality. Of course, unfortunately, what history in general has shown us and what the ATS history, and just the ATS alone has shown us, is it's those very states with the nexus to the acts which are so often either complicit in the acts themselves or the very perpetrators. So in the very first oral hearing, on February 28th, before the plaintiff's lawyer could get his first sentence out, Paul Hoffman, who was just starting his first sentence in Kiobel, Justice Kennedy interrupted him, and he said what this whole case turns on for him is whether the United States is the only country in the world to allow civil jurisdiction for universal jurisdiction cases. And then other justices also chimed in. So Justice Roberts and others as well, but Justice Roberts put it this way. He said, if the United States is isolated in allowing civil jurisdiction for crimes against humanity, that itself is a violation of international law. Is it not? Then he added, asked it as a question. Okay. So my suggestion to you is that no, we are not alone in doing that, and that this is an answer which we can get from comparative law. and that one of the things we need to do is recognize the importance of understanding foreign law in order to get there. So why is that? So the reason is that we don't mean the same thing when we talk about civil and criminal law that people in continental Europe do, that civilians do. And that there is a tendency on both sides, both for civilians and for common law lawyers, to think that we mean the same things. And why is there this tendency? It's because we have the same categorizations in both countries. And within those categorizations, in each system, there are indeed very important distinctions that are made in our criminal law system versus in our civil law system, and the same in continental Europe. But a closer look at the system in civilian countries is that their reasons for rejecting universal civil jurisdiction are not problems in the United States. So our tort law is functionally much more equivalent to their criminal law than to their tort law. Civilian tort law is often entirely in writing with no witness testimony. Civilian trials are a process. They are not conceptually organized around a concrete oral event, and they were not meant to be. So if you take even the word for trial, the word that we use for trial, we translate from languages. So if you use the French word is procès, P-R-O-C-E-S, the German word procès. So etymologically, you can see the word for process, a series. It's not the idea of one event, no concentrated event, no juries. I mean, some of these we have heard earlier today. They are private, not public. No filings in the public domain. So I know in France, legally speaking, the briefs that a lawyer will write, the memoir that you submit in court, are the intellectual property of the lawyer. No one else has access to that. So I was working with the lawyer in that case I mentioned in France. Well, he really wasn't allowed under law to give me the opponent's briefs because this was the intellectual property. He had access to it, he had to see it, but intellectual property of his adversary. No class actions, no contingency fees. And I say this in a sweeping manner. I'm glad we had some detailed explanations earlier this morning. No equivalent to what we have in the United States. So much harder for the equivalent of an ATS victim to get access to civil court. So in that 2006 case I mentioned to you in France, what happened after the lower court holding that the plaintiff won is what happened in this Dutch case that you mentioned. Also, I was so interested. Thousands of plaintiffs brought actions because you can't bring a class action, not allowed. So thousands of plaintiffs. Now, instead of letting them go up to the Supreme Court, that was already one indication of what the French were going to do. They had no mechanism for absorbing all those actions, so the case ended up being dismissed on appeal. But let me tell you, for those of you who are American lawyers, the deep problem that civilian law has with the class action that I don't believe was mentioned this morning is the idea that justice must be individualized. And in French law, there is a provision in the code, but there's also a maxim of French law that very common that says no one may be represented by a third party. One must be represented by oneself. So justice must be individualized. There are a lot of deeply entrenched principles that have to be overcome before class actions can really sit well in a civilian legal system. So judges are responsible for developing evidence in civilian countries. Lawyers are much more passive. By contrast, in the United States, there is public debate about issues that are raised in tort trials. And these debates can be very motivating for lawyers in tort law actions. So one of my colleagues has written a book called Success Without Victory about the history of American lawyers who have taken on cases not in order to win them, but in order to bring matters of social and political importance into the mainstream public debate, into society. And this is a strong factor in the United States. You can't do this. And there was a huge reaction against the court in the French case, in the 2006 French case. And some of these French commentators, some lawyers, some historians, and some just in the public who were outraged by the lower court decision to grant recovery to the plaintiffs, this is what they minded, is that these matters of French national importance could not really be thoroughly and publicly debated because it was in a tort case. That was a big problem. Now, in the French, and of course we are entitled to juries in the United States, newspapers cover the trial, etc. But in the French and German and generally civilian system, in criminal law, all of these opportunities do exist for the victims. So they are functions of those of the criminal courts, which are arranged around a concentrated oral phase like the U.S. trial. Public debate is going to be had around the criminal trial, and the victims enter into these trials, often in many countries as civil parties. So this is the partie civile. This is an institution that's well known to our courts as well. And even in countries which have some options, something like that is available. So this is a function that actually the victims' rights movement in the United States has tried to get for victims in U.S. criminal trials. But our constitutional due process concerns have not made this possible in the United States. In European countries, this exists. So the other all-important aspect is that the criminal trial in civilian states allows the partie civile to make use of the state's resources. So the prosecutor essentially does the investigation, uses the state's resources to find out what's going on. Victims will have their own lawyers, but the lawyers are not going to be equipped by training to do this. Prosecutors in civilian countries often are not themselves lawyers. So it depends country by country, but in a number of civilian countries, the prosecutors are trained as judges. They are magistrates. The term that is used is that they are standing, not sitting magistrates. So they are tasked with finding not just inculpatory evidence, but exculpatory evidence. They are nonpartisan. Their career does not depend on getting convictions. They are neutral figures. So this is completely different from the United States criminal prosecutor. And indeed, when they are promoted, they are often, their career advancement will be in another part of the country. So they have nothing like the kinds of motivations of the U.S. prosecutor, just to get as many convictions as possible in a very partisan manner. Traditionally, there is no prosecutorial discretion in the civilian state. Now this, of course, is not exactly in practical terms the case, and in universal jurisdiction situations, it's even less the case. However, I bring this up and emphasize it because when we speak of prosecutorial discretion, again, it's another term which exists in these other statutes, but we don't mean the same thing. Our prosecutorial discretion is something far vaster than what you will have in most civilian states, even with respect to universal jurisdiction cases, even in Belgium where they changed the law. In Germany also, I think that there is some real discussion about the extent to which there's prosecutorial discretion in these universal jurisdiction cases. Okay, so you see that all in all there is an equivalence. I don't say it's an identity, but an equivalence between the functions of the U.S. tort trial and the civilian criminal trial. So it's not always easy, even though we see the world shrinking with globalization, to understand what's going on between systems. Now, there is one kind of court where people really do have experience with the other system, and those are the European proper courts. There you have a hybrid body of judges, and you have a European bar, and these people, these jurists, are really habituated with dealing with the common law and the civil law. So I think it's not so surprising that it was the European Commission which wrote an amicus brief in the Kiobel case on behalf of the European Union. And the EU proposed in its brief that there be civil universal jurisdiction, however that it be limited in the following ways. It suggested that it be limited to those matters which qualify for criminal universal jurisdiction in continental European countries. Now, as far as I am concerned, although the amicus brief didn't seem to recognize this, SOSA has already done that. The U.S. Supreme Court in SOSA already so limited the scope of and the breadth of the ATS that I don't think that would be a problem. In addition, the EU suggested that there be exhaustion of remedies locally to the extent that it's feasible. And so we are now left with waiting for that decision to come down from the U.S. Supreme Court. I vacillate. I will use a crystal ball a little bit with you. My feeling after the first oral argument was that the ATS was completely finished. After the second oral argument, I was completely elated because Justice Kennedy said in both oral arguments that he did not, it seemed to me he was pretty much saying he did not want Philartica to be overturned. Then I had a nice glass of wine with Dick Buxbaum yesterday, who is very concerned that perhaps Justice Kennedy is still going to limit the ATS to Philartica, but say that corporations are not liable. My own sense is I just thought that one of the reasons that perhaps they switched the issue to extraterritoriality is that they couldn't, after Citizens United, they just didn't want to have to rule that corporations were not liable in ATS cases, but that they had constitutional First Amendment rights in Citizens United. I thought that had been my theory. On the other hand, why are they taking so long? So this isn't much of a crystal ball, is it? You have to catch me at different times for different views. It could come down any day now. So thanks very much for your attention. I think I'm going to end here, and we'll see what happens.
All right, thank you. Vivian and I were both almost exactly a year ago speaking at UC Davis at different events, not at the same panel on the same day. And we were chatting about Kiobel, which had just been argued. And we said, well, I was predicting the court will reverse the Second Circuit on the corporate liability point, and then extraterritoriality will be the next big issue that needs to be litigated. And that afternoon, we were checking our email and discovered that the court had ordered rebriefing in Kiobel. I will go out on a limb and say that it'll be a 5-4 decision with Justice Kennedy in the majority. I'm not going to talk about Kiobel primarily. My aim is to talk more generally about the presumption against extraterritoriality and what it might mean for other statutes. And I wrote an article about understanding the presumption against extraterritoriality about 15 years ago. And my aim today is to revisit that in light of Morrison. And Morrison has been criticized from many angles, but my claim is that properly understood, the decision has the potential to bring order to the chaos of the Supreme Court's extraterritoriality jurisprudence and refocus the presumption in a more productive way. So the presumption against extraterritoriality is very old in American law. It dates back almost 2 centuries. It sprang from a combination of the charming Betsy presumption that Congress does not intend to violate international law and an international law regime of strict territoriality. But during the late 19th and early 20th centuries, the strict territoriality regime began to break down. There had long been exceptions to this for regulating your own citizens or for regulating universal crimes, like piracy was the classic example. But now nations began to regulate extraterritorially on the basis of effects. And as Vivian has already mentioned, the Lotus case, the Permanent Court of International Justice held in 1927 that there were almost no limits on jurisdiction to prescribe in international law. As these international law limits on territoriality withered, the presumption searched around for a new rationale. And the new rationale it found in 1909, in Justice Holmes' opinion in American Banana, was comedy. Justice Holmes wrote that the presumption was founded on the comity of nations, and he applied the presumption to hold that U.S. antitrust law did not reach anti-competitive activities in Panama and Costa Rica. The defining characteristic of the presumption since American Banana has been how inconsistently it has been applied. The court applied the presumption in a couple of early employment cases following American Banana, but then departed from the presumption in a number of others. The most important of these, and I'm going to come back to this case several times, is United States versus Bowman, decided in 1922. The court held there that a federal statute making it a crime to defraud a corporation in which the United States is a shareholder applied to a conspiracy to submit false receipts for a ship's fuel on the high seas and in Brazil. Chief Justice Taft wrote, quote, "The necessary locus, when not specially defined, depends on the purpose of Congress, as evinced by the description and nature of the crime, and upon the territorial limitations of the power and jurisdiction of a government to punish crime under the law of nations." He said that with respect to crimes that affect the peace and good order of the community, it would be natural for Congress to say whether they encompassed acts abroad. But he said this presumption did not apply, logically, to criminal statutes which are, as a class, not logically dependent on their locality for the government's jurisdiction, but are enacted because of the right of a government to defend itself against obstruction or fraud wherever perpetrated. And he gave several examples of the U.S. Statutes that protected against, for example, stealing military property, which he said would clearly apply universally without any geographic nexus. He said, quoting again, "In such cases, Congress has not thought it necessary to make specific provision in the law that the locus shall include the high seas and foreign countries, but allows it to be inferred from the nature of the offense." Bowman, in short, defined the geographic scope of a statute by looking to Congress's purpose. The Supreme Court subsequently showed no hesitation in applying other statutes extraterritorially in a number of cases. In Cook versus Tate, it applied a U.S. income tax statute extraterritorially. In Ford versus United States, it relied on the effects principle to hold that the National Prohibition Act applied extraterritorially to conduct outside the United States, to import liquor into the United States. And in United States versus Sissel Sales Corp., it held on facts almost identical to American Bananas that the antitrust laws applied extraterritorially. The court did not apply the presumption against extraterritoriality again until Foley Brothers versus Filardo in 1949, another employment law case. The court relied on the presumption there to hold that the federal 8-hour case requiring contractors on U.S. government projects